One of the issues that we deal with on a daily basis all over the state of Alabama in our commercial driver's license defense practice for truck drivers and other CDL holders is what is masking and what conduct on the part of a prosecutor, a judge, a clerk is prohibited by the statute that is on the books as part of the Federal Motor Carrier Safety Administration rules and regulations that prohibit the masking of convictions. The first thing that we need to look at is section 384.226, and that section is entitled Prohibition on Masking Convictions. Prohibition on masking convictions. So this will tell us exactly what is prohibited. The section states the state must not mask, defer imposition of judgment, or allow an individual to enter into a diversion program that would prevent a CDL driver's conviction for any violation in any type of motor vehicle of a state or local traffic control law except a parking violation from appearing on a driver's record, whether the driver was convicted for an offense committed in the state where the driver is licensed or another state. That is what section 384.226 essentially says as it relates to masking of convictions. And it's important to note here because the title of that section is the Prohibition on Masking Convictions. That's very important to note. One of the things that I feel like is very strong and that we use regularly and I think holds quite a bit of weight in this discussion, and it is an ongoing discussion and changes daily, if not by the hour or by the minute. The state of Missouri back in, I think it was 2005, requested clarification from the federal government, essentially asking them what conduct was prohibited by the rules and regulations under the Motor Carrier Safety Improvement Act that became effective on September 30th, 2005. The scenarios that were presented to the Federal Motor Carrier Safety Administration are important because these are the scenarios that come up. The responses that were provided to the Missouri Department of Revenue are very, very, very influential, persuasive, hold a lot of weight because they describe exactly the scenarios that we deal with on an everyday basis. The first thing that the federal government said is generally for masking or diversion to occur, there first must be a judgment of guilt. Think about this. In order to mask something, to cover it up, when you're talking about convictions, in order to mask a conviction, there has to be a conviction first. That is a very important point to remember. There has to be a conviction first, a judgment of guilt. The response goes on to say further, for example, masking may occur when the court holds the paperwork on a conviction for some reason and does not allow the state to take appropriate action. That describes a situation where someone is convicted and the court holds the paperwork, doesn't send it in, doesn't enter it into the computer system, lets it sit there, and the state doesn't take an action on the person's CDL. The person was convicted, and the court masks the conviction by holding it, not submitting it. but there was a conviction first. Diversion may occur when the court allows a driver, after an adjudication of guilt, very important to note this, to perform alternative services such as traffic school to get the conviction erased. Now, in their infinite wisdom, the Alabama legislature went in and passed a statute that they thought was going to comply or help Alabama law to comply with this federal statute, and they passed a statute essentially saying no truck driver can go to driving school. And so that is on the books in Alabama. So if we operate under the state statute, then the driving school aspect is out of question. However, what we're running into is problems having charges dismissed, having charges reduced, having speeds amended, having charges amended to non-moving violations, and those are not in violation of the federal prohibition against masking convictions. It's very important that we help to educate judges, prosecutors. Everyone needs to be aware of this, because the way the law is being applied is incorrect in a lot of circumstances. There are a lot of good judges out there who will listen and who are following the law, and it's important that we help to educate everyone out there so that this law is applied in a way that is fair and in a way that is exactly as intended, and that's really the purpose here. In further videos, I'll go over in great detail the scenarios and talk about the different aspects of masking, but it's important to realize that when Missouri, another state just like Alabama, requested clarification from the Federal Motor Carrier Safety Administration regarding the masking provisions, when they responded, they indicated for masking or diversion to occur, there must first be a judgment of guilt. If we remembered that and operated on that principle alone, resolving cases prior to court, resolving cases in court prior to trial, resolving cases through the trial process, none of that is in violation of this masking statute. The federal government never intended for that to be prohibited by this statute. My name is Joseph Kreps. I'm a traffic violation defense attorney, and we represent CDL holders, commercial drivers, truck drivers in the state of Alabama who have been charged with a violation of Alabama state law that could affect their personal driver's license or affect their CDL and their ability to earn a living. If you have been charged, whether you're in your big truck, whether you're in your personal vehicle, no matter what the circumstances, if you've been charged with a violation of Alabama rules of the road, with a traffic ticket, with a traffic citation, all you have to do is call our office to begin the process with us of discussing your case and us evaluating your case with you and letting you know what we can do to help you. All you have to do is call us, 866-348-2889, or you can visit our website, trafficticketattorneyinalabama.com. Thank you very much.